This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Balmer, and today I'm excited to welcome Stephen Pope to the show. Now, Mr. Pope is a software developer, music composer, and filmmaker. He's an IP expert and consultant and has over 100 published technical papers. Mr. Pope is a sought-after expert witness with 25 years of experience. He holds a BS in electrical engineering from Cornell. Mr. Pope, thank you so much for joining me here today at the Roundtable.
I'm happy to be with you, Noah.
Let's jump into it. You've had a multifaceted career with significant accomplishments in media arts and information sciences. How did you wind up as an expert witness?
Completely by accident. It turns out in the 1990s, late 80s and early 90s, I was working at Xerox Palo Alto Research Center and also at Stanford, and published several things that years later in the late 90s and early 2000s, it seemed like every year I'd get a call from some attorney saying, "Are you the guy who published that paper?" And I said, "Well, yeah. Why?" He said, "Well, it turns out that somebody else patented that, or that, your paper would be useful to use as prior art." So I totally got started doing IP work because I had published things that at the time I published, I didn't know what to call it. And it later was called the World Wide Web, or object-oriented operating systems, or surround sound in headphones, just a bunch of things that became big things. And so by about the third time this happened, I gradually said, I better learn how to do this. So I had an attorney actually working for Apple who was very helpful and taught me about claims charts and kind of, I got the boot camp of IP research, initially only doing invalidity. So I being an academic, I love doing the background of, what's the minimum number of publications I can put together to obviate this set of claim elements. Or
Sure.
sometimes also just to support a particular claim construction. So it was only later that I realized, oh, there's all these other things going on in a IP lawsuit. And actually I've worked lately a lot on non-infringement. So doing source code review, because I'm not afraid to look at humongous source code databases. So I recently spent almost a year looking at all of Oracle, for example, for a particular lawsuit. So I've kind of done both validity, invalidity, infringement, non-infringement. I've had a very little bit of experience with valuations, but that's also a good thing to at least have come up against.
What does it mean in such a variety of fields to be an expert? And what does it mean to remain an expert?
Well, as I mentioned, in my case, the first thing is just being around for a while, because patents are always in the past. And so it's always, how aware are you of the state of the art in a particular field 8 years ago? Or in some cases, 15, 20 years ago.
Right.
The famous MP3 patents, they were being litigated up until very recently, even though the patents had all expired. They were being litigated. Well, you were still selling these products in 2017. So we're going to, and the lawsuits went on into the 2020s. So the first thing is just being, having enough experience to say in a particular field, and it could be in, it doesn't matter whether it's software or pharmaceuticals or mechanical design. I think it also helps to have kind of an academic mindset of really wanting to understand how things work and going back to first principles and good research skills, because a lot of both validity and invalidity, and I guess infringement and non-infringement are all kind of smack of research. So it's a lot of reading compared to the amount of writing.
Right, of course. Let's talk about the vetting process when you first take a call. What is it like? What kinds of questions do they ask you to make sure that, one, that you are actually an expert in the area that they're looking for, but two, that the specifics of the case work for your skill set?
Well, of course, the vetting call, there are many things going on there. So
right.
The first question is, what do they give you up front? You hope that you get a patent But I've had people just say, we're looking at litigation in this field. And there, of course, it's really vague because it's normally, database web applications, or, this one where I was working with surround sound, playing 3D sound in headphones. That was very vague, mainly because they didn't want to disclose the parties up front. I kind of guessed who it was because there's only a small number of patents in that area, but you hope that they can tell you at least what are the patents. Obviously, they will always tell you which side are you working for,
Right.
Plaintiff or defendant, and are you going to be? You hope that you can figure out, am I going to be working on, the infringement case or the validity case, or either of those opposite cases. The two other things that make you look good to ask, as soon as I saw that question, Noah, I was thinking, the first thing is, do you know exactly which claims are being asserted? Because a lot of patents have many, many claims and many groups of claims. As if
Right.
you read patents, you're kind of familiar with, blocks of claims that look identical, except for one is a method and one's an apparatus and one is a program stored in computer memory. And then all the rest of those blocks are identical, but it does make a difference if you're talking about a method patent versus or method claims versus apparatus claims. And the second most important thing I should say after that is there a claim construction? Because all of the background research and the whole thing hinges on, are they just saying everything is, they're not going to have a formal claim construction? Or is the first food fight going to be, we're going to spend a year fighting over the claims and having, your first job is going to be spending a year just writing reports on 3 or 4 very specific terms and doing a lot of research into the prior art at a given date to say that term meant something different back then. And, if they had used the common term, they never would have gotten the patent. So I think to answer the question succinctly, which I failed at the first try, Noah, the first call, it's just, I always say, yeah, I'll toot my own horn. I'll say, you've seen my CV. I know what I'm doing. Also, there's a lot going on. So if it's something out of my field, I say, I'm not confident there. You find somebody else. I have a fairly, multimedia engineering and web technology. Those two alone are huge. And in multimedia engineering, there are all sorts of standards, and those are all covered by lots of patents. So people come to me and say, how about, file systems? I say, yeah, no, there are a lot of guys that are a lot smarter than me on a lot of fields of software engineering that.
Do you find that you have to turn down a significant number of potential engagements due to this isn't really my subject area?
Just guess, probably half.
Oh, wow. Okay.
Because people are, they're attorneys, and they do a search and come up with a bunch of buzzwords. And once I realize what they're talking about, I say, yeah, the buzzwords match, but that's not really. I wouldn't be confident taking that on. And as an expert witness, I don't want to embarrass myself, and I also don't want to have people who would give me bad references about he oversold himself. So, if anything, I'm more confident. I'm more careful to say, if it's not something I'm really firm on, I'll just say probably not.
One of the things you mentioned is that you hope that you find out, and I imagine you typically do, whether or not you're going to be on the plaintiff or the defendant's side. Do you have any, differences in the way that you approach those two types of engagements?
There's a validity and an invalidity case going on in parallel, and there's an infringement and a non-infringement case. And depending on, you can read a patent and say, this patent is extremely specific and really well written, and the claim terms are consistently used and are consistent with the practice. So I would feel great doing the validity case and defending this patent. And other patents you look at and say, boy, these guys are obviously obfuscating the language because they know if they use the common terms, it wouldn't be novel. Or the patent is so vague, I'm worried about it getting challenged for even disclosing what they're doing. So I would say when you look at a patent, at least in my experience, and sometimes I've never actually turned something down to say, I don't want to have to defend this patent, but there have been some cases where I've said, oh boy, this is, and I try to be honest with the attorneys if I'm engaged to say, here are the weaknesses, or here's what we have to watch out for, or here's where I want to do a lot of prior art research to make sure there isn't something that does this, has the little flywheel just here off to the left, whatever.
So in general, do you take that kind of proactive approach with the attorneys? In as much as telling them I'm sorry, in as much as telling them, this isn't going to work, or, these strategies for this patent really are not the right direction to go, things like that.
Well, those two sentences I would not say, because those are both legal opinions also.
Right.
I'm trying to make
Sure,
sure
of
I'm
course.
not rendering legal opinions. But I can say, here are the things, these claims, here are the things I'm worried about, or here are the things I'd want to do, pay me for a week just to look at the prior art of, claim 6, element B, because I think that's going to fall apart. And I, my being honest to them, I hope makes them trust me and respect me and say, oh, okay, I'm not just saying I am all things to all people. I'll make a claim chart that, Jehovah himself wouldn't want to argue against. I'd rather say, here's what I'm worried about, or here's where I think, and I get, just recently I've had several cases where it all came down to the claim construction. That if we don't get this narrow construction, the invalidity case is going to be won. So it's, or vice versa. You can say, if I don't get a specific construction, the patent falls apart.
What are the other things that kind of foster a good working relationship between you and the attorney? What makes you a good team with an attorney?
Well, I think the personal side shouldn't be overlooked. That if I'm talking to an attorney with a headhunter on the call or not, I always want to say, who am I going to be working with? Are there other experts? Are you the attorney that's going to be my main interface? Because if it's not, I would always want to say, can I at least, when will I meet the people that will be the team that I'm part of?
Do you typically work on teams with other expert witnesses? What's that interface like?
On big trials, absolutely. I've been involved on several cases where there were a dozen or so, either the same technology on a lot of different platforms. So we're looking at one particular like video codec and how's it handled on Android and iOS and Windows and Mac OS and Linux. And so you have people doing all those different platforms, or even different people for different brands. How does Lenovo handle this versus how does Samsung handle it on their Android products?
Do you typically work with them on these things, or do you each kind of have your own part of the bigger picture, doled out?
Well, the cases where you get those big teams are basically non-infringement or infringement cases. And so we basically work independently. It's like, here's the standard, like a video codec, here's the patent and the claims that are being asserted. And we each go through and say, where do I find this particular formula? It often comes down to a formula that's in the patent and say, where can I point to, 5 lines of source code, say that source code, my expertise says that source code is implementing the formula from that claim element. So it's pretty independent because they may be in different languages. You may be dealing with things in C++, and on other platforms, it's written in a very low-level language like Verilog or something. So you can't share very much because he's looking at, my partner's in a completely different forest than I am.
Right, sure. And then when you are writing a report, do you each submit a separate report on each of those topics,
Yeah.
or is all of that you do?
Well, it all gets merged into some gargantuan tome at some point. But Appendix 3 is my appendix about whatever platform I was working on, and Appendix 4 is Fred's report about whatever platform he was working on.
Let's talk a little bit about when you are brought in the process, because I've heard from a decent number of experts that they feel like a little bit time constrained. Sometimes they're asking, hey, why didn't you bring me on in a week or a month earlier? I would have had a lot more time to be able to put this together, because there's a lot to analyze here, especially when they inundate you with a lot of paperwork at the beginning of an engagement. Has that been your experience as well?
Well, first of all, I'd like that in writing just to send out to some people. I've had both extremes. I've had people call and say, are you available to do this patent? And once I say yes, and then they say, well, gee, can you be in Austin, Texas next week? And other times I've felt like, oh, you're just trying to tie me up. so that I can't work for anybody else, because you want me to sign up for a trial that's going to be, middle of next year. And I'd love to be involved, but I'm not sure I want to, start signing non-disclosure agreements for something that you don't even, you don't even have a complaint yet, and you're trying to tie up experts so that they can't be on the other side. So it's, both extremes happen and everything in between.
Have you been brought on both as a purely consulting expert witness and a testifying witness? And has one ever transformed into the other?
Oh, certainly. I don't think that's that unusual. That I've been on teams where they say, we have 3 or 4 experts working on different components, and when we go to trial, only 1 or 2 of you are going to testify. So you may end up testifying about somebody else's report because they don't want to have all 4 people testifying. So I've had cases where I handed my work off and prepped, did deposition prep with another guy who was going to be testifying about my report, and vice versa. And in my experience, that's not that unusual. That they say, let's get the reports as good as we can, and then as a separate thing, start preparing for the trial.
Speaking of trial preparation, what are the sorts of techniques that work for you? For example, do you do mock cross-examinations, or?
If you don't, you're stupid. I mean, yeah, you do mock depositions before a deposition and mock cross-examination. And of course, the new inter partes review, your expert report counts as your initial testimony. So you go straight from writing the report to being cross-examined about it. Again, my background as a musician is you get better by stinking a lot. You practice, and at the beginning of your practice, it doesn't sound like much. So the same thing, having attorneys really try to trick you up, or try to, conflate different things like absolutely cannot be conflated. The better the attorneys, the better they want you prepared. So.
Sure. Let's talk about that a little bit, because that's something, like you said, that's something that especially newer witnesses have to go through. They have to, have their first time on the stand with all of the pressure and all of the techniques from the other side, and, having other attorneys trying to impeach their credibility, things like that. So what are the things that, you notice happen a lot, and what are some of the techniques that you use to deal with those situations?
Well, again, early on, I felt I was very well trained by a couple of clients that took the time to help me learn. And in those cases, I was valuable to them because I was a fact witness in addition to being an expert. So they wanted me on the stand because I could point and say, that's my publication, or I invented that technique that company XYZ later, and it wasn't the whole patent, it was a minor claim element. But of course, if one claim element falls apart, the claim falls apart. So,
Right.
they were very patient in teaching me. What I remember, the first thing is, you're on the stand to read your own report as much as possible. And your report has your CV, and your report has, so whenever possible, go back to your own thing. And if the attorney says, well, can't you do it off the top of your head? You're allowed to say, no, I'm under oath here, Mr. Attorney, you're not. So I've already opined on this, and I'd like to read it from my report, or at least refer to my report before I answer your question. So and sometimes they get upset both in depositions and in trials, and you just have to say, look, it's a 400-page report, or it's a whatever, it's a complex field. The reason I came here with, or the reason you gave me the print, right? Because normally they have to give it to you of your own report, and say, I've rendered an opinion carefully edited, and I'm going to repeat that ad nauseum.
Right. And they can't fault you for it. That is your right to read from the report during a deposition.
And if they, I think it's obviously they get all kinds of hot under their collar, not hot, they get excited if they have the feeling that you're going to just start improvising. Don't improvise on the stand. Don't improvise in a deposition. You've got the patent, you've got your report. If they ask you stuff that's outside, you say, I haven't been asked to opine. Do you want me to read the patent and analyze it here? I literally don't have an opinion on that. So.
Having written some 100 technical papers over the course of decades, Do you have to ever refamiliarize yourself with your own work because, due to the eventuality that the opposing counsel may come to you and say, well, 27 years ago, you said this particular sentence on the subject. Is that something that you've been confronted with?
Absolutely. No, you have to go back, especially if you're both, a fact witness and an expert witness. If you're providing prior art, that is your work, and then being deposed or cross-examined on it, you better know exactly what you said. And again, it sometimes comes down to claim construction. It's like, well, you said, the little pulley is hanging off to the left, but actually you just said it's off to the north. What does that mean? So, you better make sure that you know any subtle detail that, and again, a good team will think of that for you. You hope you're not terribly surprised, but you can go and saying, yeah, that's different. And, in my old office, my desk was facing east, so left was north. What the heck? Or facing west. So I got that wrong.
Do you have a couple of stories that you can share that have engagements that have either changed the way that you look at being an expert witness or have just in some way informed how you approach being an expert witness?
Well, gosh, what came to mind first was a couple of cases where I made the mistake I was just talking about improvising on the stand.
Sure.
The problem is I've been an academic. I taught for a long time. And when you're asked a question as a professor or a lecturer or whatever, you're always trying to think, it's just like working with kids. It's like, well, wait, I'm not going to answer that question. Let me try to figure out what misunderstanding on their part makes that question even reasonable. Whereas as an expert witness, you're supposed to be kind of an obstinate and say, I'm going to answer the question you asked and not give you help and not, answer a different question that is, I think, what you're getting at. And so early on, I had to be taught this is not teaching. This is a deposition. It's very, very different. And luckily,
Right.
most of that stuff got caught in mock depositions in prep. So the other thing I think that is just coming to mind as an anecdote was just in one particular trial I was on, the opposing side brought in somebody who was supposedly a big, hot guy to cross-examine me. This was at the International Trade Commission. And stupidly, my colleagues, the couple of days before, said, oh my God, they're bringing in Mr. X from Chicago, and he's like the best. So it makes me totally nervous, makes me, really worry about, boy, if they're worried about this guy cross-examining me. And then the funny thing was that guy ended up making every mistake in the book. He basically let me spend the whole time tooting my own horn. What the opposing side had done is they'd gone through my resume, and as an academic, you're often doing 2 or 3 things overlapping. You might be a consultant to a company, you might be teaching summer courses somewhere, you might be editor of an academic journal. So if you look at my resume, it does look like I'm juggling, at 3 parties at once. Well, they had made this big spreadsheet to try to make me look like a liar. And they had this lovely thing they projected, and then he starts off and saying, well, Mr. Pope, in 1992, you were living in Cambridge, Massachusetts. Is that true? I said, no. He said, well, your resume says you were the editor of Computer Music Journal for the MIT Press. So I got the chance to say, well, academic journals have a commission or committee that picks the editor, and the editor doesn't have to be in the same town as the publisher. So I was on the West Coast editing a journal that was published at MIT. That doesn't mean I lived in Cambridge, Massachusetts. So he continued. He didn't give up. He said, well, at the same time, you said you were living in Stockholm, Sweden. And I got to say, well, yeah, I was invited by the Swedish Institute of Computer Science to do a project there. And I was on sabbatical. And basically he led me through this whole thing of letting me brag about my resume. And his intention was to make me cry and fall apart. And at the end, this is my funniest cross-examination experience ever. At the end, he says, well, that just doesn't seem very believable, Mr. Pope. And I said, and I turned to the judge for some reason. I said, well, Your Honor, I was not married at that time. And exactly one half of the courtroom burst out in laughter. So this was a case, I think, of, you never know what to expect. And, attorneys make mistakes too. But the thing about being prepared, about being confident, he thought he was going to surprise me and make me look like the fool. And in fact, he let me brag about my resume. And in the end, he ended up not asking me a single question about my report. And his client ended up settling shortly after that for a very large bag of gold.
Wow, that's absolutely spectacular. Before we wrap up, do you have any tips for newer expert witnesses or even attorneys that are working with experts?
Well, the first thing is find out, it's just again, the academician's answer is, how can you study it? Read, get good at reading patents, first of all, and summarizing patents, because I used to teach that in grad school. I was teaching multimedia engineering, and it said, look, to the students, I'd say, look, you're lucky if you get to work on state-of-the-art stuff, which means you'll probably end up reading patents, maybe to implement them, or maybe to say, how can we do the same process without infringing? But get good at reading patents and summarizing them, and then get good at looking at patents and figuring out, well, how much of this is prior art? So a lot of that I had done before. And then luckily, the first couple of cases I was on, they just gave me reports. When I said, gee, I want to learn to write claims charts. Can you give me some? They said, yeah, we've got file cabinets full of them. And the other thing I think I said before, if you're getting started, is just ask a lot of questions. They can't fault you for saying, is there a claim construction? Can you tell me what exact claims are being asserted? That just makes you look like you're in the know, because those are two questions that any attorney coming on to the case is going to ask. So you don't, I think thinking of this kind of engagement interview as a normal interview, it's not really. Almost by seeing your CV and thinking you're relevant means you're halfway there. So the question is, can you convince them that you really ask the right questions and are a team player, are the kind of person that isn't afraid to say, I don't know, or that's out of my area of expertise.
And of course, it's important to remember that during those interviews, you're also interviewing them. You are ultimately, you can decide whether or not to take an engagement.
Certainly, it's bidirectional. I totally agree, Noah.
Mr. Pope, thank you so much for joining me here today at the Roundtable.
It's been a lot of fun. I look forward to hearing it and catching up on the other previous podcasts.
And thank you to our audience for joining me for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.